Morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Today we are going to deal with a case of Land Acquisition Act. Friends, remember from 2013 the land acquisition has been renamed as fair compensation and other things. It's a lengthy act. You all know that the government has got power to alienate any land for the purpose of public purpose. That means if they want to construct a road, definitely they can alienate any land. At the same time, they have to give the fair compensation. So actually, Gram Sabha should be held and the compensation should be fixed. Even it is a public property, even it is a private property, compensation has to be paid, particularly for the private property. If you do not pay the compensation, it is nothing but a rejection of the rights of the private persons. Please remember, forcible dispossession of private property, it infringes the human rights. It is a violation of the human right, and also, of course, it is you cannot violate the right to property as envisaged in Article 300A of the Constitution of India. Previously, right to property was in Article 19. Of course, now it has changed from fundamental rights to other rights under Article 300A. Now coming to the case, please remember, while deciding the case of Sukh Dattatraya alias Bhagat Dattatraya and another versus State of Himachal Pradesh and others in SLP number 13202 by 2020 on 6th April 2022, Justice P. Ravindra Bhatt and Pamidi Ghantam Sri Narasimha of the Honorable Supreme Court of India held that forcible dispossession without due process of law, it will definitely violate the human rights. Coming to the facts of the case, please remember, this Bhagat Dattatraya, his original name is Sukh Dattatraya, right? He claims to be the land of certain property in Himachal Pradesh. This land was utilized by the government by the state of Himachal Pradesh for the construction of some road in 1972-1973. But no land acquisition proceedings were held, no compensation was paid to him. So without observing the formalities, they have acquired his land and without paying any the so-called compensation. Right? Okay. Then he will not keep quiet. He approached the High Court of Punjab and Haryana. So definitely it has advised the state of Himachal Pradesh to initiate the land acquisition proceedings. Already you have taken position, but at the same time you have to pay compensation. For that you should be in a proper format. So therefore go for LAT, Land Acquisition Act, right? So immediately, so the proceedings under Section 4 were issued on 16/10/2001 as per the instructions of the Honorable High Court of Punjab and Haryana. Okay, the award was passed on 20/12/2001, but the award is 30,000 per biga, 30,000 rupees per biga. It was not satisfied. It was not satisfactory to our Sukh Dattatraya. Then he approached the higher courts. Ultimately, he has applied for the enhancement of the compensation under Section 18 of the Land Acquisition Act. This much you know. You cannot contest regarding the alienation. You can contest only for the purpose of the enhancement. So he has applied. Ultimately, so the collector fixed the enhancement compensation at 9,000 more, that is 39,000. And they have stated that the court directed that the collector has to pay compensation at the rate of 39,000, and if they don't pay it, they have to pay interest of 15% for the first 3 years or something. Later it will go to 12%. So as regards this interest, the government of Himachal Pradesh, they approached the Honorable Supreme Court of India. Now Supreme Court asked these people to file a civil suit, right? Because land acquisition, all these things, they come under revenue court. Now when the matter came to the civil court, now the Supreme Court clearly stated that it is nothing but dispossession. But state says So they did not dispute the possession or ownership of the person. Only thing is regarding the amount of compensation, that too regarding the rate of interest. Now Supreme Court stated that right to property, even though it's not fundamental right, it is protected under Article 300A of the Constitution of India. So the state cannot escape or cannot avoid their responsibility. So please remember, basing on the delay and latches, 15% compensation is not acceptable. Either you have to pay compensation as recommended by the district collector of 39,000, otherwise you have to pay interest. So you cannot dodge a matter by paying this appeal, that appeal and other things. So this judgment was given by the Honorable Supreme Court of India using their inherent powers under Article 142 of the Constitution of India. Please remember, so the state is directed to deem it as land acquisition and disperse the compensation within 4 months. So therefore, the orders given by the High Court that land acquisition proceedings should go on, all these things they have been struck down. Now the state has to pay compensation. If not, 15% interest they have to pay. 15% right from 2000 Wednesday, it goes to lakhs of rupees. Anyway, good judgment by the Honorable Supreme Court of India. So please read it and enhance your legal knowledge. Thank you very much.